Okay, this is part two. Um, and I'm now going to deal with what I believe is unrepresented defendants. Um, in my experience, and I suppose I'm entitled to my opinion. I'm entitled to express it, can't I? Yeah, well, I do. But in my experience, having unrepresented defendants, particularly in childcare matters, does not save money. It also puts the judge in a difficult position in trying to ensure that justice is done or visibly seen to be done. I give regular talks to aspiring young lawyers, and it's a sad thing to say that I often have to say that I do not believe that representing the most vulnerable in our society allows a lawyer to earn a decent living. Legal aid has been badly paid. It's been restricted in its um, reliability or availability. And the gap between legal aid lawyers and those paid privately is enormous. I mean, pensions, for one thing. I don't really sort of comment too speculatively, but it's interesting, is it not, that poor people, the most vulnerable in our society, tend to have trouble with the state. They tend to have trouble with the police, they tend to have trouble with the housing department or social services, DWP, childcare, big thing that can happen there. And so, if the state does restrict access to lawyers, the other one, of course, is immigration. If the state does restrict payment to the vulnerable to get lawyers to do this, it means that the vulnerable are those who will be facing the state unrepresented or at a disadvantage. The other side of the coin is that young lawyers that get qualified will go and work for the state if they're not working in private practice, where they will have a pension and a decent income and a career structure. And dare I say it, these wasted cost orders, which have been becoming very popular when I was around, of course, is never paid, is it, by anybody employed by companies or state, but it is paid by the individual legal aid lawyer. That's who pays that. So all of this needs to be looked at. We need to be able to face up and be honest about legal aid work. I'm not saying it's not. It can be abused, but we've got to cut that abuse and make sure it's going where it should be. AI again can speed up the process of case preparation, and you'll see that in John's documentation below, but also I'll refer to it in general terms. I can't go into great detail because the written submission is eloquent. So if we can speed up the process and make it more economical, then there could be a more profitable reason for legal aid being viable. I don't know, but it needs to be discussed. Case management has improved. Lawyers remain essential to the process. It's very hard to have a process of case management where the defendant is unrepresented. Politicians need to decide how to import representation into the justice system and democracy generally. The big key phrase was access to justice. I love these phrases, because having a good little phrase like a jingle, I don't know if that's the right word, a jingle saying access to justice is not an argument. It's not. Having a good little phrase is not an argument. So it's just a nice phrase to listen to. You've got to do something about it. I've seen many talented young lawyers give up legal aid work in order to work for the state. The Crown Prosecution Service being a good example. This must cause an imbalance, must it not? Surely in a democratic society, access to justice must be across the board, must be a matter of fairness. The criminal justice procedure rules, or the criminal procedure rules, can only be effective with legal oversight. And also, the cost of running cases and extra disbursements also need to be looked at. And disbursements decided more fairly, and possibly by people that know what they're talking about. The final thing is perhaps less popular with my colleagues, but I'm a great believer in the lay magistracy. There are a lot of good people that are lay magistrates, but like in any form of society, lawyers included, there are good and bad people. There are clever and not so clever people, but everybody tries their best, in my view. The lay magistrates do a lot of work in the lower courts. The legal advisors are brilliant support. My observations, I can say with some confidence that the people there are conscientious and hardworking. I've often noticed criticism from my professional colleagues over the years about the lay magistracy, and this must stop for the sake of unity, if nothing else. I've always thought our lay magistrates are great, and they work very well with district judges. If district judges and they take the time to get to know each other, and if district judges get the lay magistrates to sit with them to see how they do it, so they can see the difference, it should be part of the training, really, in a more informed way. It may well be now. I don't know. I've been out of the scheme for a long while now. District judges could also help the Crown Court. There's the provision, I think, to do that, but it's never been implemented yet. But district judges can help the Crown Court in areas which are properly selected. So, in my summary then of this part of it, I believe that the criminal justice system is often used to control the public behaviour when education is far more effective. This is a political issue for those in power. An old chestnut, really, but has the time to come to decriminalise people who are addicted to substances. Over my lifetime, we've had very heavy sentences for drug offences, for example. I've seen little positive change. If we decriminalise these individuals, drug-related offences will probably decrease. Prison population will probably shrink. Families could probably stay together. Treatment would be available, and the income of criminal organisations would be greatly reduced. And not only that, because drugs and use of substances crosses all class barriers in education, it means that a parent doesn't have to worry about an addicted child going to a gangster to get a fix. It will enable families to stay more together, and the parents and the people that are vulnerable to this can go and seek the help they need. So I think this really does need to be thought out. And I can never understand why the recent legislation over the concern for children sniffing laughing gas resulted in a prison offence carrying 2 years. I mean, could you ever get a better idea for education than that? Surely selling it, yes, that might well be a criminal offence, but really one's got to look at working with people rather than punishing people. We could even, I must say, approve pharmaceutical alternatives for some drugs. I don't understand why we've not pursued this apart from politics. That's the only reason I can see it. I can't see any other reason. Now, I'd like to consider the review of the efficiency in the criminal proceedings, which is a 2015 review. and also the Better Case Management Revival Handbook of 2023, as I dictate this. It is possible to implement a single national process using AI, starting before the charge, even at the police station. For an example would be identifying cases that can be diverted or possible pleas at a very early stage. The AI system can manage everything required through an organised system with a National Criminal Justice Operations Centre and AI laboratories. I'll refer to those a bit later on, but effectively we can get AI in the system before charging. I'm now going to start to turn with the paper that John Bowker is primarily responsible for, and this is what makes me think that nobody's actually looked at it, because I mean, I've got the paper in front of me here, and I'm going to just summarize it very briefly. But it is complex, and it seems to me that anybody reading it would benefit from speaking to the author, but they never did. Anyway, I'd be happy to hear feedbacks from you if you read through all of this and you decide to comment on it, even criticize it. I mean, criticism is also a process that helps things go forward, does it not? I'm going to say that he's talking about the operational work of two major organisations, the Criminal Courts Improvement Group and processes outlined in the Better Case Management Revival Handbook 2023 by using AI tools and techniques. Jonathan suggested that there was a creation of a National Criminal Justice AI Operations Centre and a Regional Criminal Justice AI Operations Laboratories. The key functions would be strategic oversight, AI research, centralised monitoring, ethics and governance. So that would be what he says would be the national level. On the more regional level, the AI would be using technologies in local implication in terms of the needs of individual courts, case volume, resources, demographics, and training for judges, lawyers, court staffs, using AI, having an AI help desk, innovation hubs so you can see workflows and statistics, and collaboration and learning between the various regions. He then looks at the more practical view in terms of the better case management core processes. So the AI tools can be developed to provide documents for these pre-trial reviews. He calls them plea and trial preparation hearing. I call them pre-trial reviews. So it can proactively look at the evidence, point out potential delays, missing evidence. It can help with the timely submission of case summaries, ensuring that the right information is done. It can assist with trials, certificates of trial readiness. It gives strategic benefits of flexibility, and gives help with proactive problem solving. So when a problem arises, you could use it to resolve that. And the data available will be all the data that's necessary will be available to the system. And with ethical concerns, they'll also be looked at and controlled. So in summary, what he says is that the AI National Centre and the regional labs would provide an infrastructure to manage the better case management system, and it would improve court operations and be more robust. In general terms, it will enhance efficiency, reduce delays, ensure more fairness, and will align with the framework and be a start for innovative justice reform. And that is Jonathan Bowker's submission, and I really recommend that you make contact with him if you're interested in that through the leaflet here. It's Advanced Analytica, and his email address is on his leaflet, which is attached. Right. And then we both looked at the question of AI into the current criminal justice system, looking at universities, colleges, and legal practitioners. So let's look at legal universities and colleges. Well, AI will significantly enhance legal research for students and faculty. Unlike traditional library systems, the AI platform will allow specific queries and requests. These will give extensive resources, bench book, trial data, case histories, legal guidelines, procedural rules, digital law libraries, interrogation, interaction, deep, in-depth analysis, aiding research and current and future developments. It's not just an online library. It's more than that. One of the biggest problems I found actually since I retired is I am desperately trying to get hold of information. I find it easier to get law reports from the United States than I do in the United Kingdom. I don't know why people seem to think that once lawyers retire, for all of them, their interest in the law stops. I mean, I think we should be allowed some access to legal thinking and writing and academia, because it can help other people. We have the time to do research, and we should be used more often. Anyway, a subject dear to my heart is the training of all you future young advocates and lawyers. An AI can simulate courtroom scenarios for training purposes. It can generate informed roles for prosecutors, defense advocates, and defendants, aligning with the curriculum. So in other words, whatever you're studying, the AI can give you a scenario with roles for different individual students to play, and then this can be played. Now, technically, I suppose the AI could even make an assessment, but I've been involved in practical things like this before, where I played the part of the judge to give a real life kind of effect to legal arguments by each student taking it in turns, prosecuting, defending, and so on. And to give a taste, of trying to give it a taste of really what it's like. And this would be really helpful to students, to lecturers as well, because they can get the curriculum, they can get the curriculum right on all counts in order to do the practical courses. And these kind of simulations can be using the rules of evidence, they can be using procedural law, they can be evaluated by a real judge, a tutor, even the AI judge. It will help advocacy skills. I think this is my moan again about jurisprudence, philosophy of law. Just teaching students narrative law is boring. Yeah, it's here is the law, here is the facts. Can you please give us a possible solution, or can you argue for this side or argue for that side? I mean, good Lord, Aristotle, Plato, and Socrates spent time 400 BC trying to work out what good laws should be or shouldn't be, and what good rules are and what good rules are not. And then we moved to Sir Thomas Aquinas and St. Augustine in the Middle Ages and the religion part of it. And then we moved to the World Wars. Well, there was lots of movement before that, but then we moved to the World War, and we went to Nuremberg and international law. And we had Hart and Dworkin, Fuller and Finn, I think it is, thinkers that thought about law, about why we were there, why laws is law enforceable. Politicians make law; they need to think about the philosophy behind the law and the effectiveness of enforcement for it. And this is the problem. We're seeing it today. I'll give an example. Palestinian Action. I'm not talking about politics, about or religion in this. It's just simply philosophy. It was decided to prescribe it. Now, I looked at the law at the time, and I thought we had more than adequate laws to deal with it. But no, it was prescribed. I hoped the Home Secretary had more information. You'll see, if you look at my post on LinkedIn, I actually observed this long before any court cases took place. I said, how's it going to be enforced? Because you're prosecuting people under the Terrorism Act. And all it seems to have done now is prosecute a large number of people who are middle-aged and students whose only objection or protest is what they see on the television set. I mean, I'm not excusing people that are doing criminal behaviour, but we can still enforce what we don't like through the existing criminal law. It's there. It just needs to be policed. So, but that's an example I'm giving, really, of creation of law. And of course, we do have a problem with international law, which I've got a separate paper on that, which is going to be doing in due course about international law and because you see, international is interesting because whereas most countries have state law and they have a parliament, a lawmaker, which gives it its validity and authority, international law tends to rely on agreement and consensus. And it's a rule-based thing which arose to stop future wars or world wars. And what we are sadly seeing, it's when states move away from it that we see the rule-based order collapsing. And America, of course, is a subject that I'll come to in due course. But do remember, these are all my views. But I do feel passionately about everything I say, whether you agree with them or not, is what I feel. Right, with performance and feedback then and development, so the AI is also capable of giving performance feedback and strategic recommendations for improvement in the training process of study. The AI can create, for instance, virtual witnesses, advocates, judges, and so on, giving them characteristics as well. So it's important. The reason why this is under criminal review, criminal justice review, is because obviously to the training of lawyers is relevant to the system working well. Let's have a look at legal practitioners for a moment. Advocates and judges. Well, it's a dynamic tool, AI. It's a constructive tool. It's much better than traditional libraries, even online libraries. It can provide relevant statutes, precedents, specific cases. It all depends, of course, on user input, which is what you get trained for. It can give suggestions for structure of opening arguments, closing arguments, summations. It won't do it for you. Well, I would advise you not to do that, but it will give you ideas to do that. Case preparation and analysis, strategies and content, examination, cross-examination, less likely to make mistakes or overlook something. An ingredient, if you're prosecuting, an ingredient in the offence possibly overlooked or not emphasised sufficiently well, or weakness in the evidence. AI can absorb a huge amount of documentation. So let's have a look at, for example, fraud cases, large amount of written and statistical information. AI can absorb that in minutes. The capacity for it to absorb information is not to be underestimated. So in fraud cases particularly, it can analyze data, reducing time from weeks to minutes in some respects. And then we come to the legal technologists, the professionals trained to be at the crossroads of law and technology. That's really important, because otherwise the whole system doesn't work. So we need lawyers and people like John to work together to continue review, approve, maintain the integrity and efficacy of these rules. The integration in my final submission is that AI is a significant opportunity for education and practice, enhancing legal research, training future lawyers, assisting practitioners' case preparation analysis, revolutionising the legal field. But the one thing's really important. All these things I say, all these things I mention, really depend on the integrity of the state using them. If our state puts its integrity, its democracy, its humanity at the heart of all these systems, they will work better. It stands to reason you could use this in an autocratic state and it would be a disaster. It all depends on the politicians making the right decisions. You know, we have only got a handful of people in this world that are able to bring the entire world to destruction. Plato, Aristotle, and Socrates talked about benevolent leaders. I'm afraid to say that sometimes benevolent leaders, well, I don't think benevolent leaders exist, but leaders that we have, their powers need to be defined and controlled. The Constitution of the United States did try to do that. And there is yet another discussion, an academic investigation, which I will do, probably wasting my time, and I'll put it out here. If one of you read this, one of you think about it, one of you can do something that you might agree with that might help, that'd be fine. I'm always happy to get criticism. I don't know everything. I just get very angry about things. Anyway, there we are. Thank you.